Today's in-house in focus session is about avoiding contract disputes. So, as I say, I'm gonna start the session, introduce the speakers, and finish off at the end. Then, in terms of the substance of the call, that's going to be led by Sarah and Anthony. The purpose of the talk is going to follow on from a previous session we ran about avoiding contract disputes. We're going to focus particularly on supply chain issues today, which seems to be a very hot topic. So Sarah's going to kick off talking about some of the kind of key issues, a bit of a refresher on what we did last time in a contract dispute context. She's also going to talk about what to look out for once a dispute comes up. Anthony's going to talk about trying to resolve disputes throughout the issue using escalation, and is going to focus particularly on time of the essence, using contractual dispute resolution procedures and considering termination. So that's the headlines. A few housekeeping points for today. The session is being recorded at the moment, so you'll have access to that after the session if you want to follow up, and particularly if you join halfway through, then you probably won't hear me saying this. You can ask questions throughout the session in the Q&A box. You can choose whether you want to be anonymous or not when you're asking questions. If you do choose to be anonymous and we don't get to your question, then I'm afraid we won't be able to follow up afterwards. So if you would like us to drop you a line afterwards, it would be useful if you told us who you are. Then, as usual, these things, there's a feedback survey afterwards, which is always very helpful for us, particularly thinking about topics for future sessions and live issues for you. So please do fill that in. I think that's it for our housekeeping points.
Great, thanks so much, Peter. I'll take over. Yeah, so just to introduce ourselves, I'm Sarah Jacobs. I'm a Principal Associate in the Commercial Disputes team at Mills & Reeve, and I am based in our London office. And I'll let Anthony introduce himself.
Hi everyone, I'm Anthony Minnis. I'm a Principal Associate at Mills & Reeve in the Birmingham office, and I have around 20 years experience advising on contractual disputes.
Great, so just building on what Peter said, just to give you a quick summary of where we're going today. So we're going to start off with a refresher session, which is a terrible thing for me to say in my Kiwi accent, so sorry about that. Yeah, just in general terms, how to avoid contract disputes. We're then going to move on to look at those types of issues, but in the context of supply chain problems. What do you do when you can see there are issues in the supply chain and you can see a dispute is coming? For example, you are a supplier and you can't supply something because of one of the myriad of issues affecting the supply chain these days. Brexit, boats stuck in the Suez Canal, economic uncertainty, just to name a few. Or equally, you might be sitting there and you can see that your supplier of something that you need to onward supply, whatever your product or service is struggling. And what do you do about that? Because it not only affects you, but it affects people, organisations down the stream of the supply chain. So I'm going to talk about what to look for when you're doing your initial contract review and you've got a whiff of a dispute, what might help you. And then Anthony is going to talk about what to do next. He's going to talk about, has there been a breach? Is time of the essence? And what can you do about delays in supply? He's going to talk about dispute resolution clauses in the contract and renegotiating the contract as a potential option. And then he's going to talk about the nuclear option, termination of the contract. So if we just move to the next slide, please. Starting off with a refresh. So this was, as Peter mentioned, there was a session last year in early 2021, an in-house in-focus session on what steps you can take to avoid disputes. There is a recording on that if you want to watch it again for your own entertainment, but I just wanted to revisit the key points. So, how do you avoid a contractual dispute? You want to start at the very beginning, a very good place to start, as they say, which is when you are drafting the contract. You want to be thinking, when you're drafting that contract, you want to be thinking about the disputes that often arise in the particular relationship you're contracting for, and make sure that those disputes are provided for. Because basically, it's better the devil you know. And you might want to think about including some sort of conflict avoidance procedure. You know, sometimes you see in contracts, there'll be a clause about, well, if one party has an issue with another, if there's a breach, you have to follow these steps before you can run off to court and sue them. For example, you know, you might have to appoint an independent third party to tell you what to do. You might just have to give notice of the breach and give them an opportunity to remedy it. You might have to do some sort of conciliation procedure. So think about those types of things when you're drafting the contract, and put those in, because we see they often help take the sting out of disputes, basically. It allows parties to exchange information and basically take the heat out of that dispute and get rid of it before it comes to us. So the next stage is you've got your contract drafted. What do you do now to avoid contractual disputes? And this is what we call contract management. Basically, the idea is just to, if you can and if you have time, which I know a lot of people, in-house lawyers, don't, but try and regularly review your contracts to ensure the obligations are being complied with, both for your organisation and the party that you're contracting with. And try and maintain good record keeping of that, because that will help you down the line. So, for example, if you want to terminate a contract because you're sick of this other party and all of the breaches they've been doing, if you have a record of every breach over the last year or however long, that's going to help you formulate your case for termination. Whereas if you don't have that record and there's only a very minor breach and they have the opportunity to correct that breach, then you might not have any termination rights. Equally, if the other side says to you, oh, we want to terminate and you've been doing terrible work for the last 6 months, if you have a record of you saying, oh, sorry, the delivery is going to be a bit late this month, and the other side says, oh, that's fine, don't worry about it, you can point to that and say, well, you waived your rights. So record keeping is a great thing to do. What about, you start to get that first whiff of a dispute? What should you do then once a dispute is on the horizon? We would say first thing to do is to review the contract documents and the key correspondence. If you are not a lawyer, get your legal team involved as early as possible, whether they're in-house or external. And if you're an in-house lawyer, try and get involved as early as possible. If you are the legal team, try and challenge your colleagues and sort of play devil's advocate, just to try and make sure you get all of the information from the outset, and what the other side might be saying, so that you can best protect your commercial client. Knowledge is power, as they say, so best to know all you can. Also at this stage, whilst you're getting to grips with what the contract actually says and what has happened, you also want to be thinking about commercial solutions to avoid the dispute and actioning those, whether that's picking up the phone to your counterpart. You want to bear in mind here, concepts of whether that should be on a without prejudice basis or not, and making sure you're still carrying on with the sort of open correspondence in the meantime. You also want to be thinking about, is there anything I need to do under these conflict avoidance clauses that I was talking about? Like, do you need to issue contractual notices, etc.? Right, next stage. Okay, your commercial solutions haven't worked so well. What do you do now? It's important to get organized for your dispute. So you want to be considering a few different things. You want to be considering, is enforcement a possibility? And what I mean by that is there's no point getting in a huge dispute with a party on the other side of a contract if you couldn't actually enforce any judgment or something like that against them. So if they're about to go insolvent, you want to be thinking, is this worth my time and money? Think about those things. You want to be thinking about witnesses. So who within your organization has been involved in this, and speaking to them, making sure that they've kept a record and they're not going off and deleting any documents. You want to make sure if they're planning to leave the organization that you've got contact details for them if you need to get in touch. And just on that documents point, more generally, you want to make sure that you are preserving documents as soon as you realize a dispute is on the horizon, because that's often far more powerful than someone relying on their memory alone. You probably also want to think about whether you need to notify your insurers. And you also, this is, I'll be saying this a lot throughout, but I would suggest you seek advice at this point if you haven't already. Seek some legal advice. And finally, if you are the victim of you're saying that there has been a breach of the contract, and that is what the dispute is about, you want to make sure you're taking steps to mitigate whatever losses you have. Because if you get all the way to court or arbitration or whatever it is, and you manage to show that the other side has breached their contract, they can turn around and say, yeah, we did, but if you'd done X, Y, Z, you wouldn't have suffered the loss that you're suffering. So you want to make sure that you're taking reasonable steps to mitigate whatever losses you might suffer. And finally, on this refresher point, I'm just going to do some quick what not to do's. First of all, don't terminate without having legal advice or considering what the legal basis is for termination. We see this all the time. We get a case come to us and someone has terminated the contract and they don't actually have grounds to do so. And the problem with that is that then becomes a breach of the contract itself. So terminating without grounds is a bit of a problem and it puts your organization at risk. So yeah, just make sure you consider carefully what your grounds are and whether they're enough to terminate. Don't forget to pursue commercial solutions in tandem. Don't waive privilege. So don't accidentally, send an email I send you to the other side or tell them what your legal advice says. On both of those points, so commercial solutions and waiving privilege, I would just, if you've got a plan and you're a bit unsure about whether you're running into risks with, without prejudice privilege or privilege generally, just pick up the phone to your lawyer and say, I'm about to do this. Does this sound okay? And they can steer you in the right direction. And finally, my final don't is don't ignore the civil procedure rules. So these rules just set out certain steps that parties have to take before they run off to court. And if you don't take them, then you are at a risk from a legal cost perspective. And it's basically just exchanging letters, setting out what your position is. So if you are the potential claimant, make sure you send one of those letters. And if you are the potential defendant and you get one of those letters, make sure you respond. Right, if I can have the next slide, please. So we've now got the basics covered. We're now going to pick up at that stage where you've got a whiff of a dispute, things aren't going so well. And we're going to use the example of issues in the supply chain. There's a beautiful diagram there that I've done of a very basic supply chain, which I'm sure if there's any business consultants in the room, they will say it's far too simple. But just to make sure we're all sort of getting in the headspace of the supply chain. So things that we're thinking about are staff shortages, shipping delays, problems getting materials. And the thing is that say you're the supplier there, they affect you, but they also affect whether you're going to be able to comply with your obligations onwards to the manufacturer and all the way around, basically. Noting that if you are the consumer, so on the left of that slide, if you're supplying to the consumer, so you're the retailer, you're going to have some additional obligations under your contract because of consumer law. So there are a lot of different industries and sectors here today, which is great to see. So it's this supply chain, that will look completely different for everybody. But I'm sure you can all think of a supplier to your organisation of something which you depend on to then provide your product or service. And you are also probably the supplier of something to another organisation where they onwards supply to someone else. And we're going to be sort of thinking about both if you're the party unable to deliver because of these supply chain issues, so you can't get the staff that you need, it's now illegal to contract with who you were planning to contract with, or if you're on the other side, so you can see that there's issues above you in the supply chain and you might not get what you're entitled to. Next slide, please. Thank you. So I'm going to just finish off here talking about what type of things you should be looking for in your contract when you're doing that initial contract review, and clauses that might help or hinder you depending on what side of the dispute you're on. The starting point under contract law is that you have to perform your obligations no matter what, but there are some outs in contracts that we see, so you want to look for these types of clauses. The first type is a force majeure clause. Now, I'm sure you've all heard a lot about these over the last couple of years because they didn't, no one really spoke about them, and then COVID happened and they became very fashionable. So basically, it's just a clause that says if X, Y, Z happens, this is what will happen. So, for example, if a war or a pandemic happens, the parties' obligations will be suspended for X amount of time, and if it can't be resolved, then they will have, each party will have the right to terminate with 30 days notice or something like that. It basically depends on the wording of the clause in the contract. There's no general English law of force majeure. It has to be on in the contract for you to be able to rely on it. Your clause might not necessarily be called the force majeure clause in your contract, but hopefully, having had a quick chat about them, the type of thing to be looking out for. Generally, mere economic issues are not enough for a force majeure clause to help get you out of your obligations under the contract. But again, it just depends on the wording of the clause. So just find the clause and make sure you understand what it says. Another type of clause to have a look for is what's called a material adverse change clause, or a MAC clause. Basically, these are, again, aimed at addressing unforeseen events. We see them a lot in kind of finance contracts in particular. They're quite helpful when you have the contract but performance isn't for a long time and something might happen. There might be a material adverse change in that time frame, meaning that it's, you should be able to get out of your contract. They're not often relied upon by parties when they actually get to, a court, a dispute that's actually being heard in court. because courts have interpreted those types of clauses really narrowly. But something to look out for, especially at this initial stage, and it's something that you can sort of add as a string to your bow if you're trying to get out of the contract. Something to hang your hat on legally, basically. The next thing to think about is, what about the other contracts in the supply chain? So if you have access to those, I would also have a look at them if you can, and I would also look at specifically what law applies to those contracts. So we're sort of talking about, we're proceeding on the basis that English law applies to your contract. But what we see all the time is the contract between you and your buyer might be governed by English law, but the contract between you and your supplier might be governed by, say, Australian law. So, and the different types of laws have different rules about getting out of a contract because of supply chain issues. Frustration, for example, which I'll touch on, might apply under one law and it might not apply under another law. So it means that you might be at more of a risk than you would otherwise be. Your supplier might be able to get out of their contractual obligations to you, but you might not be able to get out of your contractual obligations to your buyer, even though it's exactly the same supply chain issue affecting performance of both contracts. Another thing to look out for in your contract, is especially with if you have your supplier's contract, for example, is to look out whether they have any exclusive supply provisions or whether they can get supplies from elsewhere. Because if they say, oh, no, we can't perform, sorry, we can't, our supplier is having an issue, you can turn around and say to them, well, why don't you go and get the supply from somewhere else? Also check for limitation clauses. So those are the clauses in the contract that might say you can't, we won't be liable for consequential loss or loss of earnings, loss of profits. Or they might say we are liable, but only up to a certain figure, so £10,000, and that's a liquidated damages clause. That's just really helpful to assess your risk, basically, from a commercial perspective. You can sometimes, even if those clauses are in there, they're not always binding, but parties will try and rely on them. So make sure you have a look at those and figure out what they say. And then just finally, a couple of things to bear in mind that are outside of the contract that might help or hinder you. So the first is the idea of frustration. So you don't need a frustration clause for the doctrine of frustration to apply. It's very narrow, but helpful to bear in mind. And the other idea is illegality. So in English law, we have this concept of illegality. So if suddenly you can't perform the contract because it would be illegal, you might be able to get out of your contract. Very vague, tricky areas of law, which means they're quite difficult to rely on at this early stage of the dispute, but worth bearing in mind and potentially getting some advice on. Right, I'm now going to pass on to Anthony.
Okay, thanks, Sarah. So Sarah's talked about how to avoid disputes and the importance of effective contract management, etc. She's also talked about specific clauses to consider when experiencing supply chain issues. I wanted to talk about things to consider if you're asked to escalate matters by the business. This may be because the business believes escalation may block the supply chain, it may help the business renegotiate better terms, or because the business has lost confidence and had enough and wants to consider terminating the contract. So I really have three topics that I want to cover. Firstly, I want to consider assessing the breach and considering whether time is of the essence, which can be very important. I also wanted to look at dispute resolution procedures and how these can be helped to escalate matters. And then finally, I want to talk about contract termination, really how you assess it, how you use it as a lever, and how you avoid mistakes. Okay, so let's assume your business isn't the source of the supply chain problem. Actually, it's your direct supplier. So the business believes that components are available, but you're not the number one customer. The business wants you to escalate matters to try and secure supply. So the first step is to consider what the contract says regarding the supply and delivery obligations, and to consider whether the supplier is in breach of contract. And Sarah talked about challenging commercial, about whether this is actually a breach. Look to the contract, and don't forget to look at change controls, amendments, or variations. So what if you look at the contract and it says nothing about the time of performance? Well, this would be unusual and unhelpful, but it's not the end of the world, as there's still terms implied by statute. If you recall, Section 29 of the Sale of Goods Act states that if no time is fixed for delivery of goods, the seller is bound to send them within a reasonable time. Of course, what is a reasonable time is a question of fact. However, a course of dealing should help you articulate why they're late and therefore why they are in breach of Section 29. The Supply of Goods and Services Act has a similar reasonable time provision if the contract is silent. So what if you look at the contract and it does specify a date, but it is unclear what the consequences of breach are? Well, this is better, as you have a clear breach. However, if time is not of the essence, you cannot automatically terminate for the breach. The reason for this is the term regarding delivery is an intermediate term, and you can't terminate immediately for breach of an intermediate term. The supplier will simply say that the contract should be construed as, or the contractual terms should be construed as a warranty, and you're only entitled to damages for delay. So what if the contract fixes a date and confirms time is of the essence? Well, this is the best case scenario. You have a defined date and the time is expressly stated to be of the essence. Well, why is this important? Well, expressly making time of the essence ensures performance by a specific deadline is a condition of the contract. It elevates the term from an intermediate term to condition. And if it's a condition, then you can terminate the contract with immediate effect for breach, and you can claim damages for breach and loss of the contract. So this gives you real leverage, as you have a contractual right to terminate with cause. This lever could be enough to get you priority of supply. It could help you negotiate terms, or it could give the business an exit route if you really want to terminate and switch suppliers. So given it's so important, can you make time of the essence? Well, yes, you can. UK law doesn't require you to wait forever. If there is a severe delay, you do have a common law right to terminate for reputed breach. In order to support your position, what you can do is serve a notice, making time of the essence before terminating. This reduces the risk and again puts pressure on the supplier to meet the deadline set. So what should you say in a notice if you're going to serve a notice? We'll set out the facts surrounding delay in delivery, state clearly what they must do, and set a reasonable deadline for compliance. Explain clearly what the consequences of the default is, and that's termination. This limit is important and shouldn't be missed. You need to spell out the consequences. Now, I appreciate this is effectively a threat to terminate, but it's a reasonable one. Make sure you review the contractual notice provisions and comply with them. So if you're drafting a notice, what would be a reasonable deadline? Well, usually this is fact specific, but what you should do is you consider what's realistic. You should consider any notice or cure periods in the contract and try not to undercut them. You should also consider any commercial deadlines that the business needs to meet, where they could have detrimental effect. You should also speak to the commercial team, see if previous demands have been made by the business, and that might help support a shorter notice period. So if you serve a notice, what is its effect? Well, you're not actually making the deadline a condition. You're merely setting out your case for termination for reputed breach. The reason for this is that you cannot unilaterally vary a contract. You're simply confirming that you're giving them a reasonable time to perform, and if they don't, you will terminate. So if they miss the deadline in the notice, then you do have the right to terminate. However, it is not without risk. It is still a unilateral deadline and is subject to argument. You also need to remember that the notice itself won't terminate. You're setting up your stall for terminating a common law for reputed breach. Don't forget that you need to accept their repudiation in writing if they miss the deadline and the business wants to terminate and exit. Termination always requires a positive act. Okay, so let's switch sides now and assume your business is on the receiving end of a demand for supply. It may not be your fault, but you're still facing a demand. Well, step one, you can deny breach. Step 2, you can reject any threat to terminate and say it's only a warranty. But what if time is of the essence, or you're served with a notice? Can you push back? Well, off your best tool is the prevention principle. Can you just change slides here, please, Emma? Okay, keep going. Okay, keep going, please. Yeah. So often your best tool is the prevention principle. The prevention principle is essentially an implied term that says you cannot demand performance if it's been prevented by your own behavior. Effectively, if you can blame your customer for part of the delay, then the deadline falls away and performance is said to be at large. This means it's replaced with a duty performed within a reasonable time. Another option is to try to undermine the clause itself. Think about poor wording or wide wording. Poor wording is where the wording of the contract doesn't actually say time is of the essence, but uses a less established phrase, for example, time is of the utmost importance. This doesn't convey the full legal meaning and is therefore open to attack. Also look for wide wording where it's effectively not linked to a specific obligation or it's boilerplate. The standard time is of the essence of the contract falls into this category. Does this mean time for completion is of the essence, or is it time for every single obligation? If it could give rise to terminate the contract for only a minor breach, the court will be reluctant to uphold it. As a contract drafter, you should link time of the essence term to any specific obligations to avoid this challenge. Also look for any conflict in the drafting. A good example is where a contract makes payment time of the essence, but a termination clause says you can only terminate if payment is more than 14 days late. There's a clear conflict there, which brings the time of the essence clause into consideration. Is the buyer trying to imply that time is of the essence? Well, if your customer is seeking to imply this, they will struggle. Time performance is not usually a condition of a contract or deemed serious enough to permit termination. Good examples, however, where it would be perishable goods. And another would be volatile markets, where the price of a commodity fluctuates from one day to the next. A good example of this is a recent COVID case. It involved the supply of 5 million face masks from India to the UK. Delivery was not a condition and time was not of the essence. First tranche of masks had a delivery date and the rest would be delivered weekly without specific quantities being specified. The supplier made the first delivery but claimed they were unable to deliver the remainder due to export controls imposed by the Indian government. The buyer claimed the market was volatile and it needed to be able to terminate and to source masks elsewhere. The court implied that time was of the essence, so the buyer was entitled to terminate and claim its monies back. So if you operate in a volatile market, this could be an argument for you to deploy. So what about pushing back on a notice? Well, if you receive a notice and the time is unreasonable, say so. Assert the termination and expiry of an unreasonable period will be a repeated breach, and you'll sue them for damages for wrongful termination. Alternatively, you could confirm a longer time frame and force them to adjust the notice or risk terminating high risk. But of course, if you give a time frame, you need to be able to meet it. Okay, so next slide, please. So let's go back to being the customer seeking supply. So another way to escalate matters is to initiate the contractual dispute resolution procedure. And this is distinct from, contractual performance management discussions and meetings that usually follow. This is more considering the contractual escalation procedure, which is often like a tiered procedure. This can often go to board or CEO level. Consider serving a notice commencing the procedure if you think it will escalate the matter upward. You shouldn't discount the benefit of a face-to-face meeting between key decision makers who are not entrenched at the operational level. The escalation procedure may also be mandatory before you take legal action, so it's something you'll need to follow in any way. In terms of threats to terminate, often termination is just a lever to get what you want. You don't have to serve a notice, you can just threaten to do so, or more subtly, assert your right to terminate. If you are threatening termination or broaching discussions about mutual discharge, you should do so on a without prejudice basis. Be careful. And it's often that we say that people are clumsy and repeat threats in open emails, and this can lead to a claim for repudiatory breach or anticipated breach. In terms of a claim for damages, if you think you've already suffered financial loss as a result of a breach, consider asking the commercial team to help you quantify a claim. A quantified claim can be used to generate leverage if it can be threatened. Also consider whether you can use all of the above to renegotiate the contract if you're in a strong position, either to reflect the changed circumstances or to improve your position. Follow any change control process if applicable, and don't forget the need for consideration. Perhaps you can secure a fixed time, agree that time is of the essence. Maybe you can agree a liquidated damages clause for any future delay, or maybe you can negotiate away any exclusive supplier rights so that you'll have a contractual right to go to another supplier in the future. Okay, termination. So this is the nuclear option. So if you are considering termination, you should also consider other potential breaches and termination routes and advise the business of the risks involved. You should review the termination provisions carefully to see if they help, and consider whether you need to serve any breach notice. Does the contract include a cure period for remedial breach? And will serving a notice secure performance within this period? If you do serve a notice, make it clear what breach it covers, when it's to be remedied, and the consequences if it's not. Also think about whether the contract has a termination for convenience clause. This is the safest route for termination, but be wary. It is a no-fault termination, and you won't be able to seek damages for loss of the contract if you terminate for convenience. Consider termination at common law. This is the most risky route. This is the right to terminate for repudiatory breach. It has to be a fundamental breach and therefore carries significant risk. Sarah also mentioned insolvency. Consider whether you might have a right to terminate for insolvency. This needs to be expressed. There's no common law right to terminate in the UK for insolvency. You also need to be clear that the clause has been triggered before you seek to exercise it. Also be aware if it's your customer. Section 233B of the Insolvency Act prevents a supplier from ceasing supply because of the insolvency of his customer. This has been the case since 2020, and it invalidates your clause. Also, as Sarah mentioned, consider frustration or illegality. These are rare, but definitely worth considering. Okay, so I'll talk about some of the pitfalls. Well, the obvious ones are defective notices. You should really get external advice or make sure you get it right. Always notify in writing, by email if it's expressly provided, not by email if it's forbidden, and follow the notice provisions carefully. If there's any ambiguity, serve 2 notices, even if it seems pointless. Send by email for good measure. If you're worried that your notice is defective, serve it again and reserve your rights in the first notice. It's also possible you can waiver or argue waiver or estoppel if they've acted consistent with the notice before challenging it. Delay is also a pitfall to be wary of. When you have a right to terminate, you must exercise it. You cannot sit on the fence, or you will be deemed to have affirmed the contract. You typically have a reasonable time to investigate and to make your decision. In order to protect the business and maintain your leverage, it's best to use a reservation of rights. This will buy you time, but not forever. And best to link your reservation to a request for further information or perhaps a proposed meeting. But if you do that, make sure that you extend your reservation for another reason if necessary. Another pitfall is withdrawal. The business must understand that once you've terminated with immediate effect, you can't withdraw it. And during the notice period, perhaps you can agree to continue or vary the contract, but of course you can't do that unilaterally. Termination without cause. Well, this is the big risk. If you terminate without cause, it's a repudiatory breach, and your counterparty can accept it and claim damages for wrongful termination. And this is the risk you really need to avoid. Another pitfall that I often see is the unwanted remedy issues, I like to call it. This is where the client serves a remedial notice, secretly hoping that they won't be able to remedy, but then they do. Once remedied, you lose the right to terminate and the relationship continues. However, this is how the contract is intended to work. If you find yourself stuck in this cycle, seek an alternative exit plan. Okay, so consequences. Well, having considered the legal grounds and any pitfalls, you really need to consider the consequences very carefully. Think about damages for breach. Can you quantify and claim losses arising from the breach? Are they significant and worth pursuing? Do they have assets and money worth pursuing is another point that Sarah pointed out. And don't forget that damages can be claimed within the contract, notwithstanding the impact on the ongoing relationship. Damages for loss of contract. Can you claim losses arising from the termination? Have you been forced to terminate a good bargain? Have you suffered loss further to having to move to a new supplier? Damages for wrongful termination. Again, if you get it wrong, your counterparty may claim damages or even counterclaim for damages for the balance of the term. This is the big risk you need to avoid. Damages up and down the chain. If you do get it wrong, the supplier may seek to pass on liabilities owed to its supply chain, or your customer may seek to hold you liable for its inability to supply its customers. Check the contractual clauses on liability, exclusions, and consequential losses. Also consider other obligations on termination. Termination can trigger all sorts of things like payment of all outstanding invoices, return of property, intellectual property, and also consider if it's a services issue about TUPE. And then a final consequence really is supplier transition. Are you sure you can source an alternative supplier? Will they be reliable? Are they going to be competitive on price and terms? And also, are they suffering the same issues as your existing supplier? And are you terminated just to chase stock, for example? So lots of issues to consider if you're considering termination. Okay, so in conclusion, Sarah has recapped on some of the key steps to avoid disputes. She's covered the importance of looking to the contract, careful contract management, and clauses within the contract to consider. I've talked about the need to consider the contract and your position on breach. We talked about time of the essence and whether it's in your favor or otherwise. And can you use it to generate leverage or push back when it's used against you? Can you also look at the dispute resolution procedure or your rights to terminate, to escalate matters, renegotiate, strengthen your position, or resolve the issue? Termination is high risk and involves lots of factors. If you're considering termination, seek external advice on your rights, the risks and consequences involved, and tread carefully. Okay, Sarah, so I think I've covered the legal issues I wanted to cover. I suppose the question is, do you think supply chain issues are already easing, or are they likely to stick around for some time?
I think hopefully some of the supply chain issues that we're currently seeing are easing, but the problem is that one is replaced by another. It's like that whacking of the moles game that you used to play as a kid. And I think as well, you know, especially as interest rates are rising, we're probably going to see a fall in demand and a contraction of the economy, which means people are going to be trying to get out of non-profitable contracts. So that's just going to bring a whole new raft of issues. Right, I think that's ended the talk section. Shall we do some questions quickly?
Thanks both, and thanks for the questions we've got coming in. I think we're quite short on time, so we're only going to pick a couple to answer here. I thought I'd put a few questions that we got in, combine them into one. We had a few questions about the role of the procurement function and contract management, and I'm perhaps picking those out because that's more my part of the process. But I think Sarah covered earlier the importance of both getting the contract right at the start and then contract management during the process. The questions were really around how important that procurement function and contract management function is to avoid these disputes in the first place and things going wrong. I just make the comment that from my experience, where at the commercial end of things, we work on the contract at the outset, where there is a big gap between what happens then and what happens during contract management, that's often when things go wrong. So where the contract is set up to work in one way and what people do in reality is very different, then often we find that a lot of the issues that Sarah and Anthony have talked about do come up. That's just one from my experience. Quick question for Sarah, I think. Somebody asked, what do you mean by limitation clauses not always being binding?
Yeah, so I mean, it depends on a number of factors. Have you got a consumer contract or is it business to business? But broadly, English law says that certain types of terms and contracts have to be reasonable. So if you can say a limitation clause is unreasonable, there's a potential that you can get out of it. That's a very short answer, and can answer more questions on it offline, but that's what I mean.
I think that's probably all we've got time for now. That's great, both. That's been very, very useful for me as well. I find that I often phone the dispute spokes for quick help on things that come up when clients phone me. So bear in mind that they're a very useful port of call for people who just want to, if you want to run something past them and consider possible consequences of your actions, you don't have to go to them only when you're actually in court. So that's all for today. If you could, as I said at the start, give us the feedback, that would be very helpful. And otherwise, thanks for joining us, and see you next time.